for inviting me. I want to share with you some of the things I'm doing in my current scholarship and teaching Jewish law in Israel. What are we talking about? Well, we are talking about the way Judaism, as a religion and a culture, and its legal tradition, the halakha, is incorporated into the secular legal system of the State of Israel. So we are dealing with the role of Judaism and Jewish values in Israel. And we are not dealing at all with the Israeli-Palestinian conflict and with the West Bank or Gaza Strip. And for those of you who want to hear about these issues, this isn't the place. Anyway, I am a Jewish law professor, and that's my expertise, not in the other areas. The origins of Jewish law are thousands of years in the past, but as most other ancient legal systems are no longer relevant today, Jewish law continues to have great vitality and ability to adapt to the given time and place. And as such, it is highly relevant even in the solution of contemporary legal problems. This is manifest also in the application of Jewish law in the legal system of the modern State of Israel. Now, Americans usually speak in favor of the concept of separation between religion and state, or church and state, but in fact, although the concept of separation has been adopted in a number of countries, there are varying degrees of separation, depending on the applicable legal structures and prevalent views toward the proper role of religion in society. So we can find that some socially secularized countries, such as some Scandinavian states and the United Kingdom, have maintained constitutional recognition of an official state religion, such as the Church of England, the Anglican Church. Well, we don't have in Israel an official state religion or something like Westminster Abbey and its religious royal events. Actually, the first Prime Minister, David Ben-Gurion, had a civil marriage and not a religious one. And the Chief Rabbi of Israel, of course, doesn't have the power of the Bishop of Canterbury in the UK. But Israel is in the Middle East, and like other countries in this region, it has double commitment to both religion and human rights. Israel's constitutional system is based on two tenets. One, that the state is Jewish, and two, that the state is democratic. Now, what is Jewish and democratic? Well, you probably know the joke about the two Jews that at least have 4 or 5 opinions about almost everything. If the question would be what is Jewish and what is democratic, I assume the number of opinions are probably much higher. Well, anyway, that's Israel. That's how it defines itself. A Jewish and democratic state. Of course, we'll come back afterwards a little bit more to this definition. It is its commitment of creation of a synthesis between particularistic Jewish and universalistic democratic values that has proved to be a major constitutional challenge faced by Israel since its foundation. Reaching such a synthesis is especially problematic given that approximately 20% of Israel's citizenry consists of non-Jews, primarily Muslims, Christians, and Druzes. Even within the Jewish population itself, the exact meaning of Israel as a Jewish state has been highly contested. Not only do opinions differ to whether Jews are citizens of a nation, members of a people, participants in a culture, or co-religionists, but even within the latter, there are widely divergent beliefs and degrees of practice. Yeah, so let's see for here what we're talking about. This is 2 planets, Tel Aviv and Jerusalem, 45 minutes from each other. What's Jewish? This. Okay, so how to define Jewish values? Of course, we have a wide range, and it's only 45 minutes, these 2 planets in Israel. Remember this picture of Tel Aviv versus Jerusalem. Now, I would like to say, to clarify that when we're talking about a Jewish state, we can think about at least three meanings, and I'm referring to a well-known article of Ruth Gabizon. What we're talking about, the expression of the Jewish state. Of course, the Herzl meaning, Medinat HaYehudim, a state with a Jewish majority. This is the one limited, maybe, meaning of the Jewish state. The second one is the Jewish nation state, the state of the Jewish people. This is, of course, relevant in the negotiations with the Israeli-Palestinians, but we're not concerned about these two. We're, of course, much more concerned about the third meaning. Israel as a Jewish religious state, it's not a theocracy, because a theocracy cannot be a democratic. At least most people think that way, but it has religious affiliations. Of course, we have also two concepts of democracy, a thin concept, a more richer one, but I don't want to speak about that in this occasion. We just want to come to Ruth Gabizon's conclusion. Nevertheless, she argues that Israel can have a Jewish majority and a Jewish public culture, be a Jewish nation state, and even have a special relationship to the Jewish diaspora, that's the law of return or whatever, and accord some legal status to a Jewish religious establishment and still be a democracy, but it cannot be both a democracy or theocracy. We're not speaking a lot about this issue, but just to clarify what we're talking about when we say a Jewish state. Okay, I would like to present the challenges facing the application of Jewish law in a modern state of Israel. I shall try to point out the deserving legal models in light of the Jewish legal tradition and in light of the reality and modern state of Israel. 66 years ago, the State of Israel was established. This is a small country situated in a hostile environment with a unique type of self-determination. On one hand, it is the nation state of the Jewish people, but it also is a democratic state that guarantees, as stated already in the Declaration of Independence in 1948, and I refer to your handouts, please see source number 1, it states that equal rights and religious freedom is given to all citizens, Jews and non-Jews alike. As a rule, it is common today in the world that the public life of a state is not neutral, and in many ways cannot be neutral. As noted by the Canadian political philosopher Will Kamlika, the state cannot avoid promoting certain cultural identities. Every country, even if it defines itself as nationally neutral, reflects and practices a certain culture. And in a democratic country, this is generally the culture of the majority group. Indeed, Israel, as the Jewish nation state, promotes largely the cultural identity of the Jewish majority, which consists almost 80% of the population. Nevertheless, in recent decades, owing of large waves of immigration and internal social processes, there is increasing talk about an Israeli multicultural society within the framework of a Jewish and democratic state. Now, authors who have written about Israel as a multicultural society have included in their discussion several groups: secular Jews, religious Jews, ultra-Orthodox Jews, Ashkenazim, Sephardim, Arabs, Russians, Ethiopians. The divide between secular and religious Jews is, of course, not the only cultural divide in Israel. The state contains Arab citizens who now represent nearly a fifth of the population. I would like to focus mainly on the place of Jewish legal tradition in the modern state of Israel, which naturally has more to do with multiculturalism within the Jewish majority society, but not only, as we shall see. Already in the beginning of the 20th century, Zionist jurists understood the central role that the law will play in the establishment of the culture of the Jewish society taking shape in Israel. These jurists sought to promote a specific platform for shaping of this law, centered on reviving the legal heritage of the Jewish people, while integrating it with modern European legal concepts. But the enterprise of reviving Jewish law and making it the law of the Jewish society in Israel died following the extensive process of Anglicization that the legal community in Israel underwent during the 30 years of British mandate. As a result of this process, Israeli law was applied by judges and lawyers who had a deep affinity with English common law and with the countries that the Anglo-American law provides. But over the entire existence of Israeli law, the rich Jewish law, Mishpat Ivri, has served as a background and as a possible alternative to the legal system developing in the conjunction with the Anglo-American law. The adjudication in matters of personal status, especially when it comes to marriage and divorce of Jews, Israeli law enshrines from its foundation a comprehensive constitutional arrangement stating that the marriage and divorce shall be contracted under Jewish religious Torah law. As far as we're talking about a couple that both of them are Jews, you can see in source number 3. It is well known that despite of its Jewish majority, Israel orders marriage and divorce in manner similar to the prevalent in most Muslim majority countries. The Milat system that was established, of course, during the Ottoman regime, by granting traditional religious community courts of the various religious groups which make up its population. So in Israel, Jews go to rabbinical courts, Muslims go to Sharian family courts, and whatever. It gives exclusive jurisdiction over community member matters of marriage and divorce. What is less known, and Adam Hofri and Ran Hirschel pointed this out, is that Israel's constitutional discourse too fits a pattern common in Muslim majority jurisdiction in espousing a double commitment to both religion, in Israel's case Judaism, and to democratic or human rights. The Israeli Supreme Court has for decades emphasized Israeli constitutional law's commitment to liberalism and human rights while de-emphasizing its commitment to religion. Consistently with this approach, the court has considered Israel's marriage regime as an anachronistic blot in the law and has constructed an alternative civil marriage regime to serve the needs of Israel's secular liberals, whose views the court often echoes. There's no formal civil marriage, but a sort of alternative Supreme Court established route of civil recognition of these kinds of marriage. So let's say, for example, in the United States, they're talking about a gay and lesbian's marriage. In Israel, 15 years ago, the Supreme Court declared civilly the marriage of these kinds of marriage, civilly again. This is an example of how the Supreme Court goes. Now, what about other areas of law? Is there a significant relation between Israeli and Jewish law in those areas as well? Where here in the 1980, the Foundations of Law Act, Chok Yesodot HaMishpat, you see at source number 2 in your handouts, it decreed that where the court, faced with a legal issue requiring determination, finds no answer thereto in the statutes, the legislation, or case law, or by analogy, it means there's a lacuna, or something, a gap that should be filled. There's a lacuna in the law, and that shall be filled in light of the principles of freedom, justice, equity, and peace of Israel's heritage, in Hebrew, Moreshet Israel. The Foundations of Law Act legislation of 1980 adopted a vague concept of Israel heritage, which was naturally interpreted differently by a secular liberal judges than by a religious ones. And in light of the interpretation of the Israeli Supreme Court, which, as we said, often reflect the views of the Israeli secular liberals, the use of this law as a basis for incorporating Jewish law principles by Israeli court is quite rare. Note that there is quite similar legislation in the Egypt 1949 Civil Code, you can see in page number 3, which refers to the principles of Islamic Sharia. At the same time, when you have a lacuna, you just changed the words. Instead of Jewish law or Moshe Israel, you have the Islamic Sharia. And very interesting limiting interpretation to this term were also given by some Egyptian jurists, and as far as I learned from Norman Anderson's studies, also in Egypt, practical use of Islamic principles on the basic of Article 1 of the Civil Code in the civil courts was relatively small. Although I do not know, of course, if it's true after the current Arab Spring, the current legal system of Egypt. Now let's come back to Israel. In 1992, and you can see it again, page 1, source number 4. Two basic laws decreed that the basic principles must be interpreted in light of the values of a Jewish and democratic state. Enactment of the two basic laws of the 1992 marks a significant change in the balance of power between liberalism and Judaism in the law created and applied by the courts. Both basic laws determined that henceforth the law shall draw its inspiration not only by or from one pole, that of liberalism, but from two opposite poles, liberalism and Judaism. Between these two poles of law must enact compromises and balances. However, very little happened in terms of acceptance of Jewish law in Israeli rulings. Despite declarations about preeminent position of Jewish law in the Jewish and democratic state, in practice, the use of Jewish law in Israeli court rulings has remained fairly minimal. Here, it would be also fascinating to compare Israel's constitution to that of its neighbor in the south, again, Egypt. In Article 2 of the Egyptian constitution, you can see in page number 3 of the handouts, views the principle of Islamic Sharia as the main source of legislation. But I really don't know if that is so in practice. I'm currently learning about Sankhuri, that figure from the right, one of the most prominent jurists in the Arab world in the first half of the 20th century, and about his contribution to the emergence of modern Egyptian Arab civil law. I am especially interested in the way Sankhuri views the role of the Sharia in the Egyptian law. You can see some of what he thought in page number 2. He uses fascinating social engineering methods that he used in formulating the civil code. It's really astonishing to compare Sankhuri's enterprise in Egypt to the Mishpat Ivri Jewish law enterprise in Israel, but I don't have time to speak about that. And anyway, I'm not, again, an expert of the ways Sharia law is incorporated in contemporary Muslim states. So let's come back to Israel. Until now, we dealt with the Jewish legal tradition, especially in the context of Israel's Jewish majority. But as noted, significant Arab minority lives in the state of Israel. Are there sources of Jewish religious law that contribute to regulating the protection of the rights of the non-Jewish minorities to maintain their unique culture in a Jewish and democratic state? Well, the answer is affirmative. To illustrate the matter, I shall review a ruling by Justice Dalia Dorner, one of the Supreme Court justices. The following questions lay at the center of an appeal to the Israeli Supreme Court. Are municipalities within the realm in which there is an Arab minority obligated to use the Arab languages in addition to the Hebrew on all city signs? Like you see these examples. The question of the official status of language used by a minority is an important one in a multicultural states in general, and it arouses great interest in many multicultural societies, such as in Canada, and especially in connection with the French language and culture in the province of Quebec. The main elements of the verdict issued by the Supreme Court of Israel on this issue is beyond our concern. But it is interesting that in her ruling, this is typical, Justice Dalia Dorner learned about the fundamental right of the non-Jewish minority to speak its language not only from democracy or liberalism or multiculturalism, but from Jewish law, from the rules of Ger Toshav. Ger Toshav, the resident alien in Jewish law, she writes as follows: Obligation to allow the non-Jewish minority to use its own language is common also in Judaism. Our sources indicate that it is mandatory to recognize the language and culture of resident aliens. As such, the Jews must treat the minority as people with rights by formal recognition of their laws and culture. This is what Maimonides said, and she cites from Maimonides' code. And I think that we do not do this to the resident aliens, but try them in court according to their substantive laws. And I think that we treat resident aliens politely and generously, for we are commanded to ensure their well-being. Thus, the possibility of giving expression to cultural identity, including language, to the non-Jewish minority in Israel is derived not only from Israel being a democratic state that grants equal rights to all citizens, but also from Jewish values on which the country was founded, and which stand guard protecting the civil rights of the non-Jewish minority living in Israel. A difficult problem that many Israeli jurists faced is how to express the Jewish values in the state of Israel. Is it possible to combine content originating in religious Jewish law in a democratic, multicultural Israeli society consisting of a secular majority? And if so, how? And the most difficult question of all, what are these Jewish values that the Jewish state is expected to advance? The answer is not simple, because the interpretation a religious Jew gives to a term Jewish values is completely different from that given by a secular Jew. Remember the slide of Tel Aviv versus Jerusalem. This is the place to emphasize the dual nature of Jewish law, which reflects both the religious values of Judaism, with which religious Jews identify mostly, and cultural national values that are accepted by also secular Jews. What is the content of the values of the Jewish state? Most of the controversy on this issue arose between Judges Barak and Elon in the debate following the enactment of the two basic laws of the 1992. The two judges represent two competing fundamental concepts in Israeli society. Justice Aaron Barak, we see him above, former president of the Supreme Court, and also every year he's a professor at the Yale Law School. Remember, we said the reference of some of the judges to the Anglo-American. This is a typical example. He clearly represents the secular liberal position, which strives to make the state of Israel as similar as possible to other Western countries. He teaches, in fact, in Yale Law School, constitutional law. Yeah, American constitutional law. This is what he do in verdicts in Israel as well. Think about that. And on the other side, by contrast, Justice Menachem Elon, he was the former vice president of the Supreme Court, reflects a position contrary to that of Barak, as the principal supporter among the justices of basing Israeli law on the sources of the Jewish law. He was most well-known professor of Jewish law. He started as a professor in the Hebrew U. Even Barak grants a central position to Jewish law as a source for shaping the character of the state of Israel as a Jewish state. But whereas Barak spoke of applying the halakha at the level of values, worldviews, and basic principles, and not of a direct application of the specifics of the halakha, Elon talked about applying the halakha directly within the framework of the work of the term Jewish state. And what about the relationship between Jewish state and democratic state? Justice Barak and Elon agree that the terms Jewish state and democratic state should be interpreted as harmoniously as possible. Both spoke about striving to find the reality of the common denominator between the concepts and creating a synthesis. But a serious problem arises when there is conflict between the terms Jewish and democratic. It is the major question that divided Barak and Elon, but this is not the place to discuss their proposals. Below I present two models of solving the relationship between Jewish religious law and the state law. The first model for dealing with the difficulty of integrating the principles derived from Jewish law into the state, into the law of the modern state of Israel, distinguishes between two essential parts of the halakha: the religious parts of the halakha and other parts of Jewish law, especially those with a cultural national connection. The assumption underlying the modern usage of the term Mishpat Ivri, Jewish law, in relation to Israeli law is that there is no question of adopting the religious parts of Jewish law, because these are not accepted and observed by the entire Jewish population, and especially by the secular Jews. Adoption refers only to those legal and cultural national parts of halacha that are by and large acceptable also by those who are not religious. According to the first model, Jewish law is integrated into Israeli law only on the cultural national level, not at the religious level. It is, of course, the question is it possible to apply Jewish law at the cultural national level only, independent of its religious dimension? There are many difficulties involved in this enterprise, and it is doubtful whether is it possible to create such a separation consistently. To illustrate the difficulty in separating out the religious dimension of the Jewish law and basing it on the cultural national aspect only, consider an interesting question brought before the Israeli Supreme Court. A lawyer represented a client in divorce case in the Rabbinical District Court. And again, it has jurisdiction in marriage and divorce in Israel. At the beginning of the hearing, the judges asked him to put a skull cap, a kippah, in accordance with the regulations of the Rabbinical Courts of Israel. The lawyer asked the court to exempt him from wearing a skull cap. He claimed to be atheist, that his secular belief prevented him from any religious practice, including covering his head. His request was denied, and the court refused to allow him to represent his client if he did not wear a skull cap. So what did he do? The lawyer appealed to the Israeli Supreme Court against the Chief Rabbinical Council and the Rabbinical Courts. That's the way. If you're not satisfied what's happening in the Rabbinical Court, you can appeal to the Civil Supreme Court. At the beginning of the hearing, Justice Dalia Dorner, who is identified with the liberal secular group of the Supreme Court Justice, stressed that litigation procedure establishing an obligation that involves primarily the observance of religious commandment as a condition for appearing before a rabbinical court indeed harms the freedom of conscience of the litigants, including freedom from religion. Therefore, Justice Dorner stated, a regulation this sort is unacceptable and invalid in principle. The question that arises is whether the requirement to cover one's head in a rabbinical court expresses a religious commandment, as the lawyer claims, or is it an expression of respect for the court, similar to uniforms that lawyers wear when they appear in the court, as argued by the respondents. To answer the question of the nature of the requirement to cover one's head, Justice Dorner conducted fairly comprehensive investigation of the sources of Jewish law regarding hair covers. From the examination of these sources, Justice Dorner reached the conclusion that a head covering in a religious court is nothing but a sign of respect on the part of the litigants towards the judges, and it is not a fulfillment of a religious commandment. Nevertheless, Dalia Dorner noted, in the course of time, head covering became a religious duty. The partial head cover, the kippah, became the symbol of the observant Jew. For example, Justice Dorner cited the story of the Jewish postman in the United States who complained before the Federal Commission for Equal Opportunity Employment against the Postal Authority, which required him to cover the skull cap on his head with a service cap during his working hours, because he wanted his head coverings to represent him as a religious Jew. In her verdict, Justice Dorner pointed to a fundamental distinction between the headdress and the skull cap. In her opinion, the duty of covering one's head, not only with a kippah or hat or whatever, not this is for brown, I don't know, university hat or whatever, it's not necessarily by a skull cap, is based on a custom that expresses courtesy toward the court. By contrast, covering one's head with a skull cap has an unequivocal religious connotation in Justice Dorner's opinion. In light of the said distinction between the headdress and a skull cap, Justice Dorner ruled that requirement for a head cover in the regulations of rabbinical courts is separated from the religious commandment, and therefore it doesn't affect the freedom of conscience. There are reason, of course, to doubt the conclusion of Justice Dorner that the head covering in a religious court is nothing but a sign of respect for the court and has no connection with observing a religious commandment. From several sources, it is clear that the origins of the custom to cover one's head, even if it was initially followed only by selected individuals, are of purely religious nature. In her verdict, Justice Dalia Dorner made a biased, artificial, and misleading presentation of the Jewish sources in the matter of the head cover, motivated by the desire to adapt them to the foundations of a secular liberal freedom from religion, ignoring entirely the distinctly religious roots of the head cover. Indeed, separating the Jewish tradition from its religious sources is often artificial and impossible, but that's Israel. Just to give you an illustration of how it's complex to make a distinction between something that is considered religious and something that is considered national cultural. If you go to Israel, can you go to McDonald's there and have a cheeseburger? Yeah. Can you order a cheeseburger? Yeah, you can. If it's a non-kosher McDonald's, you can order a cheeseburger, although it's not kosher, of course. Again, there's freedom from religion. It's religious. But what happens if you order, think about that, a cheeseburger in Israel and McDonald's in Passover? What will be different?
You get it in a matzah or
the buns are made out of matzah wheat. So this is crazy Israel. And why is that? What's the difference? Because matzah, not selling matzah wheat in the public in Passover, it's a rule in Israel, so they call it a national cultural. But cheeseburger is religious. I'm not sure from where did they learn. If it's accepted, but that's Israel. Eating a matzah cheeseburger in McDonald's, that's Israel. Okay. Of course, but it illustrates how it's very arbitrary and artificial to take a scissors. This is national and this is religious. Okay, ham, outlawed pigs. This is another example. Maybe afterwards we'll speak. I refer this fascinating book of Daphna Barak Erez about the outlawed pigs. Okay.
The Brown Christian Fellowship. Yes. It's next door having a service. Speaking of freedom of religion, it's a little bit disturbing to us, but they're actually having religious service next door.
Okay, no problem.
It is, even in America.
Okay, so far we have discussed mainly the difficulties in maintaining Jewish law into Israeli law from a secular liberal point of view. But the integrative model that seeks to integrate Jewish law into the state law was sharply criticized by religious Jews. Some champions of the halacha, especially Professor Yitzhak Engelhard, argued that the incorporation of Jewish law into the legal system of the Jewish state that does not accept the binding authority of the halacha as a religious mandate, even if the incorporation is orderly and complete, is contrary to the spirit of Jewish law and amounts to the secularization of the halacha. Engelhard stressed that the uniqueness of Jewish law lies not necessarily in the solution it proposes, but in the religious outlook upon which it is based. This is not a secular law with a religious shell that can be peeled off without damaging the inside, as some believe, concludes Engelhard. This argument and other advanced by those who view the incorporation of Jewish law into the law of the state as being contrary to the spirit of Jewish law cannot be lightly dismissed. In my opinion, there is nothing wrong with the secularization of the halacha. This is part of the innovative enterprise of Mishpat Ivri, Hebrew law, which isn't identical to the religious halacha. The distinction between the religious parts and the legal, cultural, national parts of Judaism is not a new distinction. It already served at the movement for the revival of the Jewish law that was active before the establishment of the state. The heads of this movement were born in the 19th century Europe, and they were influenced by Savigny and the German historical school of jurist concept of Volkskeit, literally meaning spirit of the people or national character. And they sought to create a national secular law as part of the national revival of the Jewish people in Israel. This was to be accomplished based on the content of Jewish law, which was to be revised comprehensively in accordance with modern legal concept and with the needs of the Zionist enterprise. Note that the creators and disseminators of the new Jewish culture refer to this culture as Hebrew, Ivri, to distinguish it from the traditional religion culture of the diaspora. Similarly, the category Hebrew was adopted also by the movement for the revival of the Hebrew language, the Hebrew University, the Hebrew law. It's the same thing and it's the same time. Because these jurists did not favor applying the halacha as it stands, they used the expression Hebrew law when they referred to the law of the Jewish society in the land of Israel. This position was based on the belief that the content of traditional Jewish law ought to be converted into a new secular law based on modern legal concepts and according to the needs of the Zionist Jewish society being formed in Israel. So according to the first model, Jewish law is integrated into Israeli law only at the cultural national level, not on the religious level. And because this model really reflects some fundamental elements of the Zionist narrative, it shouldn't be rejected, in my opinion. Civil developments may be afterwards.
No. What I'm saying is that what you're saying and what's on the screen isn't the same anymore.
It's not always the same. It's not. Okay. Civil developments of sources of Jewish law are often the result of a fascinating judicial work, social engineering of the values of contemporary society of Israel's startup nation that seeks to shape ancient principles, pour them into the molds of modern law, combining the old and the new, Jewish and Western values, religious and secular concepts. The debate between, now we come a little bit to the United States, okay? The debate between the supporters and opposition of the Mishpat Ivri enterprise in Israel has a fascinating parallel in the American context, as suggested by one of the well-known Yale law scholars, Robert Cover. In many areas, Jewish law has a different ethos from that of the liberal West. In the United States, Jewish law is used and often reinterpreted to provide a requisite counter model for contemporary U.S. legal theory. One typical example of the difference between the discourse of rights versus the discourse of obligations. Robert Cover's discussion of the significant difference between Jewish law, which adopts the discourse of obligations and commandments, chiyuvim, and the discourse of rights that characterized Western law, incited great interest in American legal literature. Cover also stressed the many virtues of a society driven by a Jewish regime of duties and commandments, the creation of social solidarity, aspirations, concerns for all and more. Nevertheless, as argued by Susan Stone from Cardozo Law School, there are many problems in Cover's theory. And his turn to Jewish law in the American context is problematic because of the Jewish religion nature, which could not be easily translated into American secular legal tradition and the American narrative. It would be very interesting to examine Stone's comments on Cover's legal theory in the context of the Mishpat Ivri enterprise in Israel, but we don't have time for that. It should be emphasized, however, that some of Stone's comments are not relevant in the Israeli narrative, which is undoubtedly based on the Jewish narrative, although reinterpreted in the innovative way by the Zionist enterprise. And indeed, some of Cover's suggestions of the Jewish legal tradition concept of obligation are actually accepted and applied and contemporary Israeli law. Following Jewish law, Israeli law has in some cases adopted the obligations model. For example, we'll give two examples. One, Israeli law enshrined the obligation of children to respect their parents, and Israeli law makes a similar use of the obligations model in relations to the obligation to rescue and the Good Samaritan law. Section 20 of the Capacity and Guardianship Bill provided that a minor must respect and obey their parents. Minors must kabed et avicha timecha, like in the Ten Commandments. Several members of the Knesset opposed this section on the ground that the Knesset should not legislate in regard to personal relations between parents and children. One member supported his position with the following argument: there are things that do not require legislation. With regard to them, we have the Ten Commandments. I would understand if you proposed a sanction. For example, that a child who does not obey his parents will be imprisoned until he obeys. If you do not and cannot propose a sanction, why repeat the Ten Commandments, for God's sake? Doesn't this criticism sound like one of the arguments against Kover, which was in favor of Jewish regime of obligations without sanctions? And some of his opposition argued that this kind of regime could only work in a religious society and not in a secular society, which needs to impose sanctions on those who violate their duties. A good example of the secularization of Jewish obligation by adding a sanction could be found in the 1998 Israeli Good Samaritan law, Chok Lo Ta'amod al Dam Re'echa. Let's talk little about this unique law. Comparison of Jewish and Anglo-American law with respect to coming to the rescue of someone in distress demonstrates that Jewish law imposes the duty to help in a matter that is different from Anglo-American common law. See in page number 4 of your handouts. Unlike the Anglo-American legal tradition, example, see this horrible common law case in source number 1. In Judaism, it is the bystander's duty to come to the rescue of his fellow man who is in peril. This is a religious, ethical, and legal obligation. A citizen is expected to engage in the act of rescue both personally and at the cost of financial resources. See sources number 2. Afterwards, see what Maimonides writes about that. According to the Talmudic law, the failure to come to one's neighbor's rescue incurs no criminal sanction. To regard the Talmudic duty as moral rather than legal, however, is misconvenience of the Talmudic position. The duty to rescue is not merely a matter of conscience. Despite the absence of a legal sanction, the directive not to stand idly by the blood of the neighbor, Lo Ta'amod al Dam Re'echa, is legal just as any other norm of Jewish law. Because Jewish law embodies jurisprudence of obligation, the legal character of the duty to rescue lies in its very existence as a duty, even if its breach is not subject to a sanction. So if we look to the state of Israel, Chok Lo Ta'amod al Dam Re'echa, the rule of thou shalt not stand the brother's blood law of the 1998, you can see at source number 3 in page 4. It adopted the Jewish legal tradition that requires one to render assistance in a situation of immediate and severe danger to another. A law of this type seems unusual in the common law tradition, although Good Samaritan laws exist in many European continental legal systems, but not in common law systems. Unlike Jewish law, and this is the part of the secularization of the halakha, the adoption that the Israeli law added, the Israeli law does indeed impose a sanction. Look on page 5, section 4 of the law. It imposes a fine, unlike the Jewish law, whoever violates the duty to rescue. This is the way the secular law applies the obligation regime of the Jewish law. Indeed, this law is not identical with the halacha. But as I said, Mishpat Ivri goal isn't to incorporate into the Israeli law the Jewish halacha as is, in all its details and techniques. It is using a social engineering method which results with a product which is indeed inspired by traditional religious Jewish ethos, but is designed in accordance with the contemporary needs of Israeli society. Okay, so now let's talk about the second model. And this model talks about decentralization, pluralism, and another scholar, Professor Hanina Ben Menachem, offers an alternative model for clarifying the relationship between Jewish law and Israeli state law. The alternative model, which is influenced very much by Kover's Nomos and Narrative, famous article, proposes allowing the adoption of Jewish law into the regimes of various communities on a voluntarily basis. State law, as opposed to internal community law, would be based on pragmatic consideration that are not necessarily committed to Jewish law. That the political structure should allow maximum freedom of members of communal settlements to organize their lives according to their will, based on free choice. Communities that wish to order their lives according to Jewish law will be free to do so. Such a model would enable the development of different patterns of life according to different conceptions of the halacha. This situation is far more consistent with the spirit of Jewish law than the previous model, Ben Menachem argues, because it is more pluralistic and it is based on the consensus and voluntarily acceptance of the authority of the halacha. Despite the widespread activities of standardization, Israel has created quite a few arrangements to embody the principle of decentralization, which is perceived as the way of dealing with situation of disagreement. The great virtue of decentralization as a way of overcoming disagreement is that dissenters can all retrain their positions. Within the framework of the principle of decentralization, Israeli liberals can accept to realize comprehensive liberalism in their lives in the sub-state level, perhaps in Tel Aviv, and at the same time, religious Israelis can also expect to realize their global perceptions at the sub-state level, perhaps in Jerusalem. This model is not foreign. This is the idea underlying the federal government. So maybe we can adopt the federal system in Israel as well. That's what Menachem suggests. Menachem claims that constitutional structure of Israeli society should allow the existence of distinct communities with different legal systems that give expression to various desires of society while preserving the general federal framework. Such a model also allows giving appropriate expression to the desires of the non-Jewish population in the country, a topic that again is beyond the scope of the present discussion. In this model, the primary role of the state system, beyond addressing foreign affairs, is to ensure the maintenance of minimal moral level and to provide rules for deciding in the case of conflict between communities. It is the revolution of the privatization of law. The possible contributions of Jewish law to this revolution and to the constitutional structure that will follow is great and instructive. Now I finish with what I think, the desired model. I believe that Israel should adopt a combined method that includes side by side the two models mentioned above. We are not to settle only for the principle of decentralization and the federal model, but must also strive to integrate Jewish law in the state legal system, especially in light of the fact that Israel is a small state which has a population of only 8 million. What makes the analogy that Ben Menachem does to the federal system in the United States with a population of more than 300 million very problematic, of course. Integrating Jewish law, at least its major cultural elements, not all the religious elements, into the Israeli state legal system is essential in order to properly shape the state and the social framework in a Jewish and democratic one within Israel's multicultural society. In my opinion, this follows also from the Jewish legal tradition. But first, let us examine the issue from the perspective of the literature of multiculturalism. How to think about shaping the Israeli center under conditions of Israeli multiculturalism. It is possible to offer several normative imperatives based on Professor Menachem Mautner's book. The central imperative of preserving Israel's democratic liberal regime is self-evident, but there are also two additional relevant normative imperatives. The first imperative is the principle of decentralization. We discussed above various examples of its adoption in the State of Israel. But even a state that adopts the principle of decentralization cannot fail to put it in place a large number of uniform normative arrangements, first and foremost through its courts. Thus, there is also a second normative imperative, the imperative of expressiveness, which means that the normative arrangements of the state should reflect the normative perceptions of major cultural groups living in the country. According to this conception, the law of such a state is the product of the people's lives and reflects the spirit of the people. In other words, it is created from the bottom up. Despite the criticism against the expressive conception of the state, it seems that the prevailing view among liberal thinkers is that no country, not even the liberal state, can operate without with only normative neutrality. The multicultural state should make sure that unique normative concepts of all the important cultural groups are manifest in the state laws. As far as the state of Israel is concerned, many believe that the challenge of the next generation should be a turn of the Supreme Court into a state institution that both religious and conservative Jews and secular can also identify with, and for the law that is created and applied in the court to observe the imperative of expressiveness even when it comes to religious and conservative Jews. Implementation of this normative vision does not necessarily mean turning the halakha into a binding legal source in the ruling of the courts. But this means that sometimes there's a need to the law to speak in religious language. In a multicultural society, it is important that the state court know how to talk to members of sub-societies and various communities in their own language. This also applies to non-Jewish population in Israel, and that is why we have Arab Supreme Court jurists. You see Jubran there, and why we find many Arab judges in the districts which have a big Arab population, such as the Galilee and North District, and in the South District as well. Adoption of integrated model that combines side by side both the principle of decentralization and the federal model, together with the integration of Jewish law into a state law, is the proper way of shaping the state and social patterns of a Jewish and democratic state within the multicultural Israeli society. Generations of Jews dreamed about the return of Jewish sovereignty in the historical homeland of the Jewish people. They envisioned this country and its selected institutions to be working to promote that unique Jewish culture, not only in their communities and in the private domain, but also in the general public sphere. The Jewish state should show the whole world the collective realization of the Jewish narrative, common cultural identity shared by all Jews. This, of course, should naturally come together with pluralism and respect for the others, Jews and non-Jews, to express their unique cultural identity in their community. That is the designed model, in my opinion, and that would really reflect the values of Israeli society. Thank you very much for your patience and all the technical problems. Now,
Take the question.
yeah. You know, I'm Israeli, although I have a suit. I'm used to, you can throw tomatoes on me. And you can criticize. That's what I'm here for. Yeah, so if you have any questions, of course, I would love to. And please present your name. Yeah.
Yes, Sandra.
Sandra.
I guess I'm a little bit confused about this merging of the values of Israeli society. Having spent 6 years living in Israel, and most of my friends, not most, all of my friends were secular. And on Friday night, we would go into Tel Aviv and go to Cafe Safta, which was the only place I think that was open. And there was a great resentment that Jewish law was closing every business that wanted to stay open. That was number one. Number two, I don't believe that the dominant Israeli culture is based on Jewish law. I mean, I think that's an enforcement, and that was seemed to have been a compromise of some sort. I think, if I remember a little bit of history, Ben Gurion gave in to a lot of the religious population to, I don't know whether it was after the Holocaust or whatever, but it would seem to me that if Israel had a constitution, and I never understood how is it possible that a democracy does not have a constitution, that you would solve all of these problems. And you want, the religious can go to their synagogues and have their whatever, but that family law required that you go through all these. I mean, most of my friends got married in Cyprus, and their children were considered mamzerim. It just seemed ridiculous in a way. So I don't know how you.
Well, you ask all the questions. I can.
I know,
5 hours.
just
I can answer.
hodgepodge.
I'll answer of part of them. First of all, a democracy without a constitution. England doesn't have a constitution. Israel was after England, so it's not the only democratic. United States is not the only country in the world democracy. They think that they invent. I mean, England doesn't have a constitution, and Israel is like. And another thing, to get agreement between two Jews, that's impossible. You said one narrative. In Tel Aviv, that's the Tel Aviv values. Go 45 minutes, it's a completely different country. They see what you said and the opposite side. And if you look in the Knesset or whatever, you can never know what is the majority. Just one thing to take in consideration. According to all statistics in Israel, I'm talking about the Jewish population. You mentioned religious and secular, but probably the biggest proportion of Israeli society is what's called Mesorati. It's traditional. It's somewhere in between. It preserved some religious things and some not. I don't know if they live in Tel Aviv, probably more in the periphery and whatever. What you said about, only I'll answer very briefly on the reflection of religion. It's maybe my fault. I should clarify when I said Jewish law, said Mishpat Ivri. I emphasized that it isn't the halacha as is. It's the way that Israeli law, Israeli society tries to incorporate some views in a way. So I'll give you an example, and maybe it relates to the pigs, or another example to Tisha B'Av. This is a religious law, the outlawed pigs. In the 50s, it was a consensus. You cannot raise pigs in Israel. They're way to curve and whatever. Why is that? And I refer to a fascinating book of Daphna Barak Erez in English, Wisconsin print, so about the outlawed pigs. In the 50s, it was a cultural national symbol. The pig, the literature, Hanan Shivad Banea, something that symbolized, and it was accepted by most population. She shows what happens, especially after the 90s. The Russian immigrants came, and the dietary ways of eating maybe is different. And you see today, although formally the law still exists, the way it's interpreted currently, a few years ago by the Supreme Court, it depends more on the municipality. So it's considered more religious. And they say, for instance, if it's an area that they don't have a lot of religious Jews there, they could sell or they could raise the pigs. Whereas in areas that are more, and I think this is a good thing. This combines to what I said the decentralization, give freedom to the municipalities to do whatever deserves to their society. In Tel Aviv, just to give another example of Tisha B'Av. This is Tisha B'Av, the fest of 9th of Eve. There is a law in Israel that considers that a sort of a national Jewish day. But of course, you don't need to fast there. What is prohibited? To open, let's say, cinemas and theaters. Usually, also restaurants. In Tel Aviv, recently, a few years ago, the legal advisor of Tel Aviv municipality said, you know what, restaurants you can open. And they opened it. And the current legal situation is in Jerusalem they give their interpretation to that law, municipality in Tel Aviv. I think this is a good way of dealing with these things. I think it should be a paradigm for other solution. What you said, the last thing about civil marriage, that's of course one of the, if you didn't understand from what I say, I should emphasize that if I'm towards legal pluralism, I think you should open the route for civil marriage. But you mentioned, and that's true, whose fault is many of these religious laws? It's Ben Gurion. The same thing, that's the truth. Because of the Mamlachtiyut, he brought it. I'm not sure that he was concerned about the unity of the Jewish people, of the support, and whatever, the same thing. So it's something to think about. Yeah.
So I don't understand why it is that it is only legal for an Orthodox rabbi to marry two Jews and not for a Reform rabbi.
Well, this is the question. This is the question of between the religious movements of Reform, Conservative, Orthodox, and this is a very typical question. I have to say, first of all, that the Supreme Court declared, at least on we're talking about conversions, they accepted the conversions of Reform and Conservative as far as the law of return and whatever. There was one of the biggest demonstration of the Haredim after that, and of Barak. This precedental law changed in other issues as well, as far as using the money to build and whatever. And now they're seeking for the compromise of Neshot HaKotel is the same thing. The Orthodox hegemony, look, it's hard really to explain because when I say it, people feel not comfortable. This is a democratic state. You don't have Reform and Conservative parliament members in Israel. And that's really the only reason. I mean, if there was pressure, no, why not?
People don't vote.
Because they're not citizens of Israel. They don't. I have to tell you the truth. You go to Israel, in most of the places, it's very rare to find Conservative and Reform. It's not the United States. I was in Haifa, maybe one conservative shul in whole Haifa, in Jerusalem. I saw two, okay, but about 200 Orthodox. That's what I mean. So no, it's something that you have to understand. In order to change things, you have to vote. You have to have parliament members. It's not. The truth is, I want to say more than that. For the Israeli secular, they don't see the Reform or the Conservative as something that they accept or something like that. That's religious. That's the American version as well. There's no pressure as that. So, if a lot of Reform and Conservative people were in Israel, I'm sure the Agmoni. That's the real truth.
I don't
That's the
understand
practical
justification
truth.
from a legal point of view. That's what I don't understand.
Yeah.
It's not legal then, it's just the majority rules.
What? It's not legal?
No, you
That's
said-
democracy. I'm not understanding. People
Which
that
is-
are not citizens of Israel don't live in Israel, and they're. I
Are you
don't
saying
understand.
there are no
It's a very
Jews
small.
in Israel?
Hmm?
Very small percentage.
Very small.
very
Very,
percentage.
when I say very,
I want to say something about it from the point of view of a cultural historian, and from a point of view of a person who didn't live in Israel for 6 years, but for many more years than 6. So first of all, I want to say something about Ben Gurion. I mean, it's a kind of myth that Ben Gurion wanted the Orthodox to like him, and that's why he initiated this exemption of the Orthodox, of the Haredim, it has nothing to do with reality. Ben Gurion, in the first government, the first coalitions, he had a huge majority. He didn't need them. He didn't need their support. This was his understanding that this is what it means to be Jewish. The Reform movement in Israel, nobody knew about it. It wasn't even as strong in America.
They're anti-Zionists, they were.
They were anti-Zionists, that's right. And Ben-Gurion hated them because they were anti-Zionists. This is one thing. The other thing, most people didn't object it. People accepted it. People wanted it. So, of course, things developed. Now, I want to say something about Tel Aviv, but before I say something about Tel Aviv, I want to say something about what you mentioned here about the reforms in Israel. You have to understand that what you define as a secular Jew, the vast majority of the so-called secular Jews in Israel are very similar to Reform Jews in America. They're very similar. I mean, they have kind of tradition. They have every week a Shabbat dinner. They celebrate Shabbat in a way which is not very far from a Reformed Jew in America. So, and this is one of the main reasons why the Reform movement doesn't succeed to attract people in Israel, because people are actually reformed without knowing it. Now I want to say something in Tel Aviv. About Tel Aviv. I want to invite you to take a walk in Tel Aviv on Friday night between 5 and 8 and to see how many people are on the streets and how many people are in the houses. And this will be the answer.
I've heard that Arab citizens are restricted from buying property.
What?
Is that true?
Well, I just want to mention, just because you said that notion, this is maybe an example of the other side of the democratic and Jewish. There was a Ka'adan case in the Galilee, considering Keren Kayemet L'Israel. The Supreme Court declared there was a village that was wanted in the Galilee, was oriented to be open only for Jews or those that served in the IDF. The Supreme Court canceled that obligation because it was not equal. There was no problem of Arabs to buy property like everybody, and I don't understand. From legally, there's no difference between Arabs or whatever. It's business, someone will want to sell and someone will not. But legally, there's no restrictions on Arabs to buy. No way.
Any of the students have questions?
Yeah.
I had a question about the qualification you made at the beginning of your talk about not talking about the conflict, and I was wondering if that was just because of a whole separate topic, or if you see halakha, or like what you talked about here, as very separate from that. And I think in my mind, I really connect.
First of all, it's separated because this is law and religion. We're not talking about here. This is the third notion. That's what I started, the Jewish state. Affiliation to religious subjects. I'm not an expert in political science, so what can I tell you? I hope that there will be a compromise. That's true. Will this strengthen the model of the Jewish and democratic state? Of course it will. Yeah, but this is not. This is politics, and this is not my profession. I spoke about the way it's inside. The Jewish law. I just mentioned one notion to think about, the resident alien. Resident alien, ger toshav, that means a citizen that is not Jewish in the state, and this is according to Jewish law. He accepts the 7 Noahide laws. all Muslims are by definition accepting these kinds of laws, he deserved to get all the civil rights and equality, and his culture is he's not supposed, according to the halakha, even the Jewish law is not governed on him. He has his laws, and you should recognize his laws, no hide laws. One of it is the dinim. He can establish the legal system that is recognized. So that's the only refresh what I refer to.
Take
That.
2 more questions.
Yeah, please.
Can you talk a little bit about the legal justification for the law of return? Because it seems like it would maybe rely too heavily on Jewish law.
Well, again, the legal justification of the law of return is not Jewish law, it's Zionism. And you know what, maybe let's read it in the handout. You can see it in the Declaration of Independence. You can see, let's read it in source number 1. The land of Israel was the birthplace of the Jewish people. Here, their spiritual, religious, political identity, for those that had said, Jewish was not never, or religious was not never, it's only the religious people. It was always inside, you can see it. Judaism is both national, it's both religious, it has all these, political identity was shaped. Here, they first attained statehood, created cultural values and national universal significance, and gave the world to the eternal book of books, the Bible. The state of Israel be opened for the Jewish immigration and for the gathering of the exiles, kibbutz galuyot. What does they say here? I can illustrate from my personal family. No place was open for Jews. That's the truth. Thanks God I'm here because my grandfather ran away from Germany and he had a son that was Zionist and brought him. And the same thing, my other grandfather from Galicia with Yaldei Tehran, he went inside everything. So the basic is Zionist. This is a country, never again the gates would be closed for the Jewish people. And this is why they say here at the beginning, it's open for Jewish immigration. Because the other places are not like that. And look at the facts. The United States were not open. Canada was not open. They only opened the gate after they had Israel. That's the truth. And you should take that in mind. The other thing that they mention here is gathering of the exiles, kibbutz galuyot. Kibbutz galuyot, this is one of the visions of the Zionist vision. The state of Israel is considered, and this maybe does relate in another way to what you said, and I have another point of view on that, sees itself not only as the state of its Jewish citizens, but the state of all the Jews in the world. In that way, it does have the linkage with the diaspora, but it believes that, and this is Zionism, that they should come to Israel. This should be the central of the Jewish civilization. So it's a national Zionist law, and you can see here the basis on it. And I think this is something that explains it. This is not a Jewish law. This is a Zionist law. Okay.
One more question, and then if people want to ask individually afterwards, but after this one right here.
Yeah.
So what is your opinion about the Orthodox serving in the army? I think that's definitely one area, a good example of like the challenge of like pleasing different
Well, first of all, I'm Orthodox and I served in the army. So, okay, you can say I'm a modern Orthodox or a religious Zionist. You're talking about Haredim. This is a good example. Let's see how the mechanisms start. We had this compromise of Ben Gurion that maybe didn't think, or I agree, that it was not only practical reasons. He had Mamlachtiyut as a philosophy, is more than that. And he gave this compromise with the ultra-Orthodox that don't go to the IDF. The things are changed, and it's not something that the Israeli society can accept today. The numbers are different. And the tension, we have to say, this is another thing, the 50s is Mamlachtiyut. The 90s and afterwards is the tension between Shas and Lapid. Yeah, they grow with each other. The tension Tel Aviv, Jerusalem, these two opposites. So we have this tension. Who started all this? The parliament did not want to solve that. The Supreme Court, the last president, the Supreme Court, Dorit Beinish, the last day she was in order, she canceled the Hoktal, that because she says it's not democratic, it's not equal. And from that start, the parliament, the Knesset, are striving to find, because it's not legal, the Supreme Court canceled the last, to find some way. The question is, and that's what I see currently in Israel, and they say we'll have a big demonstration of Haredim. Of course, it's more wise from a cultural point of view not to do everything by coercion, by sanction. If you want them to feel part of the society, and that's the real, I think, goal of all these things, they want these parts of Israel to be more productive, to have education, and the IDF is only a symbol, it's only a beginning, because that brings them inside. It should be, and that's, I think, what they're doing. It should be something that you do very delicate, very thinking. Maybe the sanctions are not so extreme, maybe in stages, maybe the equality will not be 100%, but you're going toward a process. Maybe it should be negotiation with the Haredim leaders to have a sort of a compromise. The problem that today, the Ben Gurion notion of pshara, papainikit, the compromise is less. Israel is more tension between things, and everyone wants to beat the other side, and it's hard to do that. I think it's very important for the Israeli society, for the Israeli economy. If this is the way, I'm not sure. I think you should have to do it in have a conversation with this population to tell them enough is enough and we need you inside, but in a positive way, not in just throwing on them. That's my personal view. It won't work without that. They'll see it as another symbol of these people that are trying to are against the Torah and the Judaism and whatever, will go to jail. There are people that will do that. That's my opinion.
Thank you very much.